Good morning, and thank you for joining us for the April installment of our monthly webinar series. Before we get started, there are just a few housekeeping items that I want to address. First, right under the presentation slides, you have the ability to type and submit questions. Please feel free to ask questions throughout this presentation by using this feature. Everyone logged into today's program will receive an email that includes a link to the recording of the webinar as well as the presentation. Now let's get started. First and foremost, my name is John Swinney. I am an associate here at Franczek. I'll be one of your presenters today. And I am joined by a partner here at the firm, Jackie Wernz. So as an introduction, today we are talking about student data privacy. And in order to have that conversation, we first need a basic lay of the land of the laws that govern these issues. So first, at both the state and the federal level, there are laws that govern the release of student records. FERPA is the federal law, and ISRA is the state law here in Illinois, which I'm sure all of our K-12 districts are very familiar with. Generally, under those laws, you cannot disclose student records unless there is written consent or an exception under the law that applies. Now, the second law that you see here, COPPA, or COPA, depending on how you want to pronounce it, is the Children's Online Protection Act. It is a federal law that protects the privacy of children under the age of 13. This can come into play sometimes when students at the elementary and lower middle school levels are using online services that collect their data. There are requirements under COPA or COPPA that either the parent consents or in some circumstances that a school consents to collection of certain personal data. So this is, if you go to a website and it asks for your name and then it asks, are you above the age of 13, that's because of this law. They need permission to collect certain personal information regarding individuals under the age of 13. And finally here, as we'll discuss in just a minute, the Illinois Student Personal Protection Act is a law that was passed in 2017 in order to ensure that operators of websites and online or mobile applications that are used for K-12 purposes protect student information that they may collect. For practical purposes for today's presentation, we've organized this presentation as a top 5 trends or things to keep in mind about student data and records under both Illinois and federal law. So that's kind of the model that we'll take in going forward today. And starting with the first one, we have online educational services. This is a trend that we are seeing in the educational realm for sure. More and more school districts are entering into agreements that involve the sharing of student data, including data that could potentially identify students. These agreements include contracts ranging from essential day-to-day operational services, such as student information systems, and agreements for technology products, such as photocopiers and telephone systems, to contracts for the use of educational technology in the classroom, like Google Apps for Education. These agreements also include contracts with organizations and other entities to conduct studies on behalf of the school district and on behalf of schools for the purpose of improving instruction. At the same time, parents are increasingly concerned about districts sharing data about their children. Now, in working with clients, we've learned that many would benefit from more robust policies and procedures to ensure that contracts contain terms that sufficiently protect student data and are in compliance with state and federal law. Policies and procedures should address who can enter into agreements to share student data and ensure that training is given to confirm that employees understand any limitations on their roles. Such policies are crucial in mitigating the risk of liability, either in parental lawsuits or contract disputes with a vendor. For this reason, we advise school districts and charter schools to, at a minimum, make sure that they are reviewing all the terms of a contract, including those incorporated terms, to ensure that the terms are not detrimental for the district or for its students. We further advise that school districts and charter schools revise policies to ensure that student data is being adequately protected in accordance with the law. Now, as I stated earlier, one of the main laws governing the use of student data in K-12 districts is the Online Protection Act, which was passed in 2017. Generally, this law applies to K-12 districts and its vendors or operators that are operating internet websites, online services, online applications, or mobile applications that are either designed for a K-12 purpose or used for K-12 instruction. As the law is currently written, it really mainly only applies to those operators and vendors that I just discussed. But this is set to change with the current amendment that is working its way through the General Assembly. HB 3606 would alter the current law in several ways. First, it would require that operators implement and maintain security procedures and practices that better protect information from unauthorized access. So in that way, it does impact the current vendors and operators and adds more stringent requirements. But it also lays out additional obligations for school districts and for ISB in contracting with these vendors and operators. So there are certain requirements that you're going to have in your contracts with these individuals going forward. It also prohibits schools from selling covered information, private information about students, or sharing this covered information without written agreement. This HB 3606 would also require school districts to post certain information on their websites, including an explanation of the data of covered information that the school does collect or discloses to any other individual, and a list of operators that the school has written agreements with, and a copy of each of those agreements posted online. This bill would also finally add a Student Data Protection Oversight Committee that would be appointed by ISB to ensure compliance. Now, it's important to note that this law is still only in bill form, meaning that it has not been passed yet by the legislature. It did, however, back in early April, gain the approval of the House, and it is currently before the Senate, where it does appear that it has substantial support. We here at Franczek are working with state and educational institutions to make recommendations to the General Assembly regarding the content of this bill, with an eye towards making sure that it's feasible for school districts. So we will be sure to keep you updated as these changes come forward and as we have a better understanding of what this bill might actually look like as it gets closer to publication.
Thanks, John. So this is Jackie Wernz, and I'm now going to talk about our second issue that we're going to be discussing today, which is the definition of student data. So John just walked us through some of the considerations to keep in mind, obviously, with respect to contracts involving student data. But in order to do that, you have to first know what student data is. And this is really an age-old question for us in this area of law. We've been grappling with this for a decade at this point, and we still don't really have clear answers. And the first angle I want to talk about with respect to the definition of student data is in relation to these contracts that John was talking about, because I really think it highlights for us why this is such an important issue. So if you have a contract with a vendor and they are storing a bunch of student data for you, if that data is considered to be a student record, then parents have things like rights of access. Now, some of that might come into play under some of this new legislation that John mentioned, but even without that legislation, if the information that the company has is a student record, then the parent arguably has the right to view that information and even to contest that information. And that's really important for us, because if every single little tiny bit of data meets the definition of student data, then we're going to find ourselves in situations where parents are potentially holding up a lot of school operations in order to try to gain access to information that's housed by vendors. I don't have a clear answer for you on what would fall within the definition of student data. What I can tell you is that under both the federal law, FERPA, and the Illinois law, ISRA, the definitions of student record information or educational record information is very broad. It's really generally any information that could individually identify a student. And so because that definition is so broad, one of the terms that we want to see in contracts with vendors is something to protect us on the off chance that the law is interpreted to require us to give parents access. So I want to see something in my contracts I negotiate that says, hey, you vendor, if I get a request as a school district for some information that you only have, that you need to give it to me, and you need to give it to me in a timely fashion. This is also just generally something we try to include in contracts with outside vendors for public entities, because you are subject to the Freedom of Information Act, and you don't want to find yourself in a position where you need a record to respond to a FOIA request and you can't get it from your vendor. So that's really one angle with respect to this definition of student data that is evolving and I think important for you to be aware of. The second angle deals with videos and photographs of students. So this is, again, a topic that has come up again and again and again. And it usually comes up when a student is facing some type of discipline, or there's been some type of incident at a school involving students, and someone says, I want to see copies of the video files or the audio or the photographs that were taken of this situation at school. And we have to determine whether or not a school can release information that might include pictures or video of other students. And the Family Policy Compliance Office, or FPCO, which is the part of the Department of Education tasked with ensuring compliance with FERPA, has recently given us a flurry of guidance about what is considered to be a student record when it comes to photographs and videos. And what they've said is that you need to consider whether the record is directly related to the student or students who are shown in the video. So some of the factors you're going to consider to make that determination are, what is the school using the record for? If you're using a video or a photograph for disciplinary action involving a student as either the offender or the victim, that's going to weigh in favor of finding that it is a student record for that student. Now, if the student is just incidentally in a record that's not really being used against them, they're not the focus of the picture or the video, for instance, or they're participating in some activities that are open to the public, it might not be an education record for that student. So again, you have to look at this on a case-by-case basis and determine whether or not this video or photograph actually directly related to the student. The photograph or video also has to be maintained by the school to be an education record. So the FPCO's guidance clarified that where a video or photograph that was taken by a third party is given to the school as evidence of, say, a disciplinary violation, then it becomes a student record because it's at that point maintained by the school. Now, I sort of alluded to this earlier, but where a photograph or video is the education record of multiple students, and there's a request by the parent of one of those students, for instance, to see that record, what do? So you can redact out portions of the record that directly relate to other students to the extent that that is possible. You can't charge parents for that, but you can and you should do that if it's possible. If you can't redact it, if it's not reasonable to redact it, which is very true in a lot of cases, the parent has the right to access the entire record. So under FERPA, a school isn't required to just deny a parent's request because they can't redact out other students. Now, again, this is going to typically come up when you're dealing with a student who's facing some type of disciplinary incident or something of that sort. So hopefully you're going to be working very closely with your legal counsel on that issue anyway, and then we would be able to advise you specifically on how to proceed. But I have seen a misperception amongst school leaders in the past that, you know, if we can't redact it, then that means the parent doesn't get it. And the FPCO has said that's not really going to be the case. If the parent needs access or has the right to access to the record, if you can't redact it, then they may have to be able to see it. You don't necessarily have to give them a copy of it, but again, they maybe need to see it. So also something to keep in mind, all of this guidance that I've been talking about from the FPCO reflects the analysis under federal law. The analysis under the state law that John mentioned, ISRA, is similar, but it's not identical. And so again, you know, we really recommend that in situations if it's a close call, that you are working closely with legal counsel to make a determination about whether something fits this definition of a student record. All right, so our third topic is student threats. And I have a picture here of our president with a copy of a recent report that was issued by the Department of Education on school safety. This was all over the news. And one of the things that came out of that report is that the Department of Education has thought through and issued some additional guidance about how you should respond to student threats and what information you can share about a student in the face of a threat. So as an example, if you have videos or photographs that are created and maintained by a school and they are education records, technically they can't be turned over to the police without parental consent. However, under the federal law, and there's an identical provision in the state law or a similar provision in the state law, if there is a health or safety emergency, then you can release that information. And also, if there's been a court order, you can release that information. And so it's important to understand that what those standards are for when is there that health and safety exception or emergency that allows you to release it. And there was a recent primer from this organization called the Future of Privacy Forum. It's a nonprofit organization that puts out a lot of good information about data privacy. And they issued this really interesting 2-page document for schools that talks about things to consider when you are considering releasing information in the face of a student threat. And so the primer reminds us that to do this, a school official, which could be a member of a threat assessment or emergency response team or someone else, they must be able to articulate why they reasonably believe a student poses a significant threat before they can disclose student information without consent. And the primer includes 4 specific recommendations for school leaders about releasing student identifying information in an emergency. And I think these are really good to keep in mind. Number 1 is to have clear guidance in place before an emergency about what student information can be disclosed. So right now, you should be working to come up with some guidelines or procedures for your staff to know, okay, we're going to go down this list and we're going to do these things in order to determine if these standards are met. And if you need help with that, you can always reach out to John or me, and we'd be happy to assist. Number 2, you're going to make sure that you're limiting disclosure to only the information that is absolutely necessary to resolve the emergency or safety issue. That might mean that the only thing you're going to release is name and email or other information that is directory information. It might in some cases require that you release really specific student record information, but you need to have made a determination of why you need to release the specific information that you're going to let out there. Number 3, you're going to limit disclosure to individuals with a true need to know the information. And so this can in some cases include students if it's necessary to help protect against a threat. But it's not always going to include students. It's not even always going to include all of the staff or all of everybody at your school. It might be that you are just notifying law enforcement and letting them handle it. But you do need, again, to make sure that if you're going to tell anybody, either within or without the school community, about this student record information, that you have made an explicit determination that that person has a true need to know the information in order to address the threat. And then finally, there's this suggestion that you weigh unintended consequences against the benefits of monitoring disclosure. So there's some concern that if schools don't distinguish between disclosures in response to a specific articulable threat and general school surveillance programs, that's going to lead to a higher percentage of minority students being either subject to school discipline or reported to the police. And so to unpack that a little bit, what you're looking for is very specific threats. Something that is, where you can say, this person is going to engage in this conduct and hurt this person as a result of it, as opposed to general school surveillance programs where you're really, sweeping in every comment or concern that could possibly be raised about students. Because what the research has shown is that there are high correlations between high levels of school surveillance and high percentage of minority students being suspended. So really, again, what we're suggesting you do here is to at least take some step to consider whether there are any unintended privacy or equity consequences when implementing programs to monitor student information in the interest of school safety. All right, moving on to number 4, due process. So this is a little bit of an outgrowth of what we were talking about earlier when we were talking about what is a student record and what record information does someone have a right to. And I've had this come up in so many different contexts. I can't even tell you. There are so many. So I've had this come up at the Department of Education when I was at the Office for Civil Rights, where in Title IX, schools are often very reluctant to release any information about what the results of an investigation were, because they're concerned that if I say to a complaining student that we found sufficient evidence that the responding student engaged in sexual harassment against you, that you are releasing student identifying information about that responding student. And a lot of districts are, I think, understandably uncomfortable about doing that. This has come up recently in a teacher dismissal proceeding that I'm working through where, the students of a teacher are the witnesses. And what information can we release and how do we go through the process of making sure that we're respecting student record rights while also providing due process to the person who is accused of some misconduct. And this is a really tricky balance. What I will tell you is that there is authority out there that suggests that you need to have either parental consent or an exception to FERPA in order to release student information, which would include, arguably, information that a student provided to the administration about allegations that they're raising against someone else. And so how do you deal with this? I would say that the number one thing you do is that you always want to try to work to get consent. If the student is the one who's raised the complaint against the teacher, their parents are likely going to be more than willing to consent for you to release information. If you tell them, in order to discipline or dismiss this teacher, we have to provide information about who made these allegations against him and what they said. And in many cases, parents are going to be fine with that being released as long as you're seeking, as you should, a protective order. Where it gets a little bit more tricky is when it happens without the involvement of an actual lawsuit or a proceeding. You've got a student who comes in and says, I'm being bullied, and you need to allow the other student to defend themselves. You may not be working with a lawyer. You're just calling that student in to defend themselves. And what do? Again, it's really important to explain to the complaining student and their parents the limitations on confidentiality that you can provide if you're going to pursue allegations against another student. And really, if it comes down to it and you've got parents that won't agree, then really your only way out is you're going to be seeking a court order in order to require release of the information. And that would fall under a FERPA and ISRA exception. All right, our final issue today is cybersecurity. So this sort of pulls together a lot of what we've been talking about today, whether it's information that's housed in an online service provider's servers or a copy of a written document that a teacher is emailing around to other staff. and potentially could send to the wrong recipients. Schools are very tempting targets for cyber criminals, and that's because of all the information that you maintain about students and employees. You have demographic information and social security numbers, medical information, test scores, all sorts of things that can be stolen and sold online. So really we're facing two-sided risk here. One is information that is inadvertently released either by one of these online service providers or teachers, and then on the other hand it is cyber criminals who are coming in and trying to get information that you have that is of great value to them. Now, there are detailed state and federal laws that govern what steps you actually have to take if there is a response to a security breach, and we could do a whole session on that. But what I really wanted to talk with you about today is the press and some of the studies that have been coming out about training for staff and how important that is for addressing these types of safety threats. I saw a statistic that said that up to 95% of all data breaches occur because of human error. And the best way to prevent that from happening or to mitigate that risk is to train people. And so we really highly recommend that you are using engaging, hopefully live training, because I know when I was at the Department of Education, I had to take tons of cybersecurity training, and it was all online, and you could just click through and take the quiz, and you could be done with it in 5 minutes. But what you really need to be doing is live, active training. Call in outside organizations. This is something we can help you with. There are tons of other service providers that can help you with engaging training on these topics to teach staff members about these risks. Also, apparently phishing scams are one of the biggest reasons that schools are subjected to cybersecurity breaches. And so that is where you get an email and it looks like it's from something legitimate and it says click here, and when you click there you're letting the bad guys into your computer. And one of the best things to do for that is to run regular phishing tests at your school. So these are like fake emails that get sent out that are phishing emails, and when you click on it, it says, you screwed up. But at least that can reinforce and keep on people's minds that this is a risk that they need to be on the lookout for. So, I saw a news article where a superintendent, they implemented a program like this, and were shocked to see that 20% of their staff was what's called fish prone, which means that they were unprepared to recognize or report phishing attempts. And that's a huge number, depending particularly on the size of your staff. So increased education, heightened awareness, cyber hygiene training, which is, I just love the sound of that for some reason. It's like you and your computer in a bar of soap. That is really the way that you are going to best prevent these things from happening. If they do happen, you're going to call your legal counsel. You're going to follow all the steps that are required to report it. But taking those steps at the outset can really help mitigate the risk. All right, we are right up on our end of time. Let's see if we have any questions we can get to. All right, here's a good one. What if you have a relationship with a vendor that includes standard terms from the vendor which state that they assume you are attaining parental consent, so they are COPPA compliant, and you're not obtaining parental consent for these services? So this is a big, fun issue. I will just tell you that the short answer is you have generally the right to sign off or get consent from parents, or essentially you're acting in loco parentis. You're taking their place by giving COPPA consent. if you have that term from the vendor that says they assume you're attaining parental consent, I would try to get them to neutralize that language a little bit. And I've actually had luck with that in some contract negotiations, even with big vendors. Just to neutralize it, to say something like, we assume that the school district is taking the necessary and required steps to comply with COPPA, instead of saying, we assume you're actually obtaining parental consent, because I don't believe that you are required to obtain parental consent. All right, and let me see if we can do one more. What if you're live streaming a sports event, a concert, or a graduation, and there's a parent request to not show an individual student? I mean, the short answer is that we've got some good evidence or support for saying that if you, student, are in attendance at a public event, that we can take video of you and that's not a student record. If you're showing up in public to do something, not a student record. That said, I typically recommend that you get out some language to parents. It doesn't have to be a consent form. It can be more of just like something in your handbook or somewhere that says, hey, just so that you know, if your student is in attendance at these things, we will be recording and live streaming. FYI, if you don't want them to be on the stream, then they don't show up. It's a little bit more complicated if you're doing those live streaming things and they're less public events. In those cases, it's going to be a lot more necessary for you to take some steps to get consent, or at the very least to give an opt-out for parents if they don't want their student to be included. All right, we don't want to keep you guys too late. Thank you so much for joining us today. We will be having another webinar next month, and please keep an eye out for your email for more information about that upcoming event. Thank you.